House Bill 544 by Representative Jordan. We were here last week. We previously adopted Amendment Set 2051. So that's on your should be in your folders. So Representative Jordan on your bill, House Bill 544. So.
Again, members, this is House Bill 544, dealing with legislative continuances. I think we had some discussions last week. I think we may have some amendments based on conversations with the chair.
Yes. So, all right, members, there's Amendment Set 2388. So I'm going to ask Ms. Pirtle to go through those amendments.
Yes, Mr. Chairman. This is Amendment Set 2388. It is made public and given to you. Amendments 1 through 5 are technical. Amendment 6 adds that the continuance or extension provided in this section shall not be applicable to incidental demands or third-party demands that are barred by prescription or preemption, and that's provided in CCP Article 1041. Amendments 7 and 8 provide that attorney fees, court costs, and sanctions may be available if the opposition to the legislative continuance or extension is not grounded in fact or in compliance with the provisions of CCP 863, which is relative to attorney signature as a certification of the pleading. Amendments 9 and 11 move veto session to its own item in subparagraph E1b. Amendment 10 adds organizational section to subparagraph E1a. Amendment 12 renumbers the provision relative to legislative continuances or extensions founded upon subparagraph C1c. Amendment 13 deletes changes related to timely motions to continue or extend legal deadlines prior to a hearing or proceeding on a motion for sanctions or penalties brought by opposing counsel for failure to comply with a legal deadline. Amendment 14 deletes amendments to present law F1 that would strike the inapplicability of the legislative continuances to cases in the Supreme Court. And Amendment 15 deletes changes requiring recusal of judges who deny a motion to continue or extend legal deadlines.
Thank you, Ms. Pearl. One of the discussions we had is, does an extension extend a prescription deadline? And under 1041, if you file a reconventional demand and you have 90 days, you kind of get a 90-day extension. So this is to make sure that that doesn't apply to that. You don't get more time than the rest of the world does to file to bring that required matter within the 90 days. Also, we clarified some grounds on dealing with the organization veto sessions, and because of the veto session, we kept paragraph 2, but we pushed that to subparagraph III on page 3, lines. It's between lines 15 and 19. That if the grounds for the legislative continuance or extension are founded upon any provision and is unable to comply with notice requirements, you have to give notice at the earliest time practicable prior to the hearing. We added that for a veto session because of the way our veto ballots are required. We say it's 4 days prior to the hearing or proceeding to be continued, or no later than 2 days because of that. We also deleted, of course, line 3, 21 through 26, and I think Representative Seabaugh may want to talk about that again. And then on page 4, we've deleted lines 1 through 3 because we don't. My understanding is they don't want to exempt. Right now, the Supreme Court cases are exempt, and we're going to leave that alone. So we're not changing the law on that, and then we got rid of the recusal portion. So, all right, Ms. Pearl says she has one correction there.
Yes, members. On page 2 of the amendments, line 3, it should say if the grounds, not just if grounds.
Okay. All right. Any questions on that amendment? On those sets of amendments?
Okay.
All right. Seeing none, I'm going to go ahead. You got
Got a question.
Representative Jenkins. Okay, go ahead.
Yeah, all right. Now, and I want to be, thank you, first of all, thank you, Mr. Chair. I really want to be clear because, there are very few things that we have available to us, and this is one, the continuance, which I deem is something that's generally done in very good faith. So I'm not clear on understanding why are we removing? I don't want to remove anything there that would provide for some kind of extension of a deadline. I don't care if it's incidental demand or third party demand or whatever the case may be. I don't want to remove anything that currently is provided for in law.
Yeah, and that was not the that was not the intention to remove what's already provided for in law. And we're looking at
This is amendment number 6. It said, notwithstanding the provision of this subsection, the continuance and extension provided by this section shall not be applicable to incidental demands and third-party demands that are barred by prescription or preemption as provided in Code of Civil Procedure Article 1041.
Yeah.
So what exactly are we doing?
I know. So you know how you have the mandatory. If I have a case that would prescribe, let's say someone's filing suit against me for a car accident, and I wasn't planning on filing suit against them. They file suit on the last day. Well, I'm required, if I wanted to file suit for damages for my damages arising out of the acts that the plaintiff is alleging that I'm responsible for, I have a mandatory 90 days to I have to bring I have an extension. Everybody has an extension of 90 days to be able to bring that action. I don't think current law allows that to be. I don't think current law on legislative continuances grants us that extension, and I don't want to give a legislative attorney who's handling a case extra time to bring a lawsuit.
And then help me. Thank you. I appreciate it. I think so. Help me also understand here amendment number 8. What exactly are we doing that saying the opposition is not grounded in fact or in compliance with the provisions of Code of Civil Procedure Article 863?
Normally the provisions for sanctions is provided in Code of Civil Procedure Article 863D, but Representative Jordan wanted to make sure that we have it specifically have a special call to the attention of the courts and the practitioners to have language about sanctions in the section dealing with the legislative continuances. But I wanted to track the language that we have in the Code of Civil Procedure that says, look, just because somebody opposes something doesn't mean that they should be subject to sanctions. It has to be if they're not well grounded in fact. And that's the language that we use in 863D.
Okay. And, I do want to point out, too, for the committee, especially the non-lawyers, this body of law for this continuous, not just for lawyer, it's for any member of the legislature. And the only reason I bring it up, I heard some questions, the last time the bill came up. It's for any member of the legislature. This is not a lawyer thing. If you're a member of the legislature, then this, it applies to you. And it's very difficult to be in two places at one time. If we're in session, we need to have time to do what we need to do here, as well as try to take care of things that we need to take care of as a part of our practice. Representative Jordan, what do you think of these amendments? Do you have any concerns about any of them?
So I think that let me start with, I guess it was the one that you were just talking about, the one about sanctions. I do think we have the peremptory right. I do think that it should be without contradiction or explanation. However, in talking to the chair, there might be some situations where, if it's not in good faith, for instance, that someone may want to file in opposition. And in those cases, I think he's saying it should be grounded in not grounded in fact on compliance with the provisions. I think that's a compromise that we agreed upon. The only thing that I really had an issue with was and one thing that we were adding was dealing with Amendment 15, I think it is, that deals with the recusal. But I think everything else we were good. And I think in talking to the chair last week, I told him I thought that was the only one that of those things that we really had a real issue with. Although I understand what you're saying on Amendment 6 and some of the other ones, but I think those things. Look, we're trying to clarify. I'm certainly not trying to take anything out of law that is already in law. And so to the extent that it does not do that, I certainly don't have any objections to it.
And then Amendment 15, so we're removing out the recusal provision.
The recusal provision, right. And I'd like to, frankly, I'd like to keep that portion in there. But that's something that is new, that is added, that came in this year.
And if the recusal is requested, that would be a hearing on the recusal.
It would be.
Right? So there still would be
a hearing on
it. And Representative Jenkins, we still have the right to recuse a judge under the existing recusal article. So if there's grounds for a recusal under the existing recusal, this provision that he was proposing would say that just the denial of a motion. It doesn't even say whether the denial was even valid or not. If that just seems like it's going way too far, and that's why my amendment strikes that.
So I know we have some grounds for recusal, some of which are not discretionary, but would any of those existing grounds actually cover this particular reason, though? Would we not have to add this to the reasons?
The way the language of the bill reads currently, without my amendment, means that even if someone was untimely, if they untimely filed a motion, or if they didn't have the grounds for a continuance, for a legislative continuance, then the legislator could, or employee of the legislature could say, "I want you out, Judge." So, and this would be unprecedented, I believe, in law. Special provision for legislators. So, all right.
That's the only one I'm telling you of them that I had objection to. But of course, it's the will of the committee as to adopt them all, though.
All right.
Well, what is the current motion? The motion is to adopt all of them.
I'm going to make a motion to adopt all of them. If you'd like to vote on that one separately, I'll be glad to.
Yeah, well, I'd like to make a motion to adopt all of the amendments except amendment number 15.
Okay, well, I'll make the motion that we adopt amendments 1 through 14 in amendment set 2388. Hold on, with one little caveat Ms. Pearl needs to tell us about.
Yes, Mr. Chairman. We staff would like to reserve the right to make any technical changes because if it might need to be taken out or removed.
Sure. All right. Okay. With that, motion is to adopt amendments 1 through 15 in amendment set 1 through 14 in amendment set 2388 with also a little change on in amendment 11 line 3, it should say if the grounds for a legislative continuance or extension are founded. So with that little caveat, I move that we adopt those amendments 1 through 14. Any objections? Seeing none, amendments set 1 through 14 of 2388 are adopted. All right, now back on amendment number 15 in amendment set 2388. I move that we adopt amendment number 15, to which Representative Jenkins is objecting. So, Ms. Sanders, please call the roll. Thank you.
Representative Amade? Yes. Representative Boyd? Yes. Representative Robbie Carter? Representative Wilford Carter? Representative Eccles? Yes. Representative Emerson? Yes. Representative Freeman? Yes. Representative Garofalo? Yes. Representative Hodges? Representative Jefferson? Yes. Representative Jenkins? No. Representative Johnson? Yes. Representative Knox? No. Yes. Sorry, that was a yes for Representative Knox. Representative McCormick? Representative Muscarello? Yes. Representative Nelson? Yes. Representative Seaball? 11 yeas, 1 nay.
Thank you, Ms. Sanders. Okay, so with that, amendment number 15 is adopted on amendment set 2388. Now we're back on the bill. I don't see any cards in support. We do have a card present, not wishing to speak, present, and in opposition, Jennifer Prescott. Also, members, we had received a letter from Kim Sport and in opposition, and that is will be put into the record of the proceedings. Representative Jordan, you may close on your bill.
Look, it's in a posture now that I think it's in the agreement up to the point that you and I had agreed, and 1 through 14, and with 15 going on, it's in a posture I think that's acceptable to the chair. It's in a posture I think that we're ready to move forward. It really does some clarifications in the law, and I'd ask for your favorable passage.
All right. Thank you, Representative Jordan. Representative Jenkins has moved that we report House Bill 544 with amendments. We have an objection by Representative Eccles. Oops, I keep jumping the gun there. Representative Eccles has objected to the motion to report with amendments by Representative Jenkins. Ms. Sanders, would you please call the roll?
Representative Amade? No. Representative Boyd? Yes. Representative Robbie Carter? Representative Wilford Carter? Representative Eccles? No. Representative Emerson? No. Representative Freeman? No. Representative Garofalo? No. Representative Hodges? Representative Jefferson? Yes. Representative Jenkins? Yes. Representative Johnson? Yes. Representative Knox? Yes. Representative McCormick? Representative Muscarello? Yes. Representative Nelson? Yes. Representative Seaball? 7 yeas, 5 nays.
Thank you,
All
members.
right.
I appreciate it.
Thank you. With that, Representative Jordan's House Bill 544 is reported with amendments.